The Supreme Court sided with a January 6th rioter this week, ruling that a law criminalizing the obstruction of an official proceeding does not apply to his actions or the actions of other insurrectionists. Now, the Democracy Docket notes this means sentences could be adjusted for hundreds of January 6 defendants who have already been convicted. Joining us now is the founder of Democracy Docket, Mark Elias, and former federal prosecutor Ankush Khardori. Ankush is a senior writer for Politico magazine. Mark, can you just expound upon your Democracy Docket piece right there? What the heck did the Supreme Court do this week as it relates to this particular case?
Yeah, look, I think the most important story of the week, and I recognize there's a lot of other politics going on, may very well be that the U.S. Supreme Court undercut one of the main prosecution tools that the Department of Justice has used to prosecute January 6th defendants at the same time that Donald Trump took to a debate stage and refused to commit to abide by the outcome of the 2024 election. This case involved the application of what I thought was a very straightforwardly worded statute that made it a federal crime to obstruct an official proceeding. And a majority of the Supreme Court interpreted that, given its history and the structure of the statute, to only apply in instances where that obstruction involved documents or records or other tangible items, and it very well may lead to the dismissal of a number of charges and resentencing of individuals, including the dismissal of charges against Donald Trump. Now, it won't undo those cases in their entirety in most instances, and it won't undo the case against Donald Trump in its entirety, but it sends a powerful signal right now to a bunch of people who are planning to subvert the election in 2024 that they may just be able to get away with it.
Your point was taken up, actually, by Justice Amy Coney Barrett, who broke with the conservatives this week, noting Fisher's alleged conduct, which includes trespassing and a physical confrontation with law enforcement, was part of a successful effort to forcibly halt the certification of the election results. Given these premises, the case that Fisher can be tried for obstructing, influencing, or impeding an official proceeding seems open and shut. So why does the court hold otherwise? Ankush, why does the court hold otherwise?
Because they are completely...
I'm sorry, but yeah, you're right.
They are completely opportunistic textualists among the conservative, the Republican appointees. I agree with Mark. This should not have been a close call, legally speaking. It is worth noting that Justice Jackson joined the majority here, so we shouldn't be just totally one-sided about it. But I do think the correct way to read this law was for it to apply to all of the people that it's been applied to. However, I will just say that on a note of optimism, I think the practical impact of the ruling is likely to be much narrower than I think people currently think, because the most obvious application of this decision would be to people who had only charges under that statute and who are still either yet to be sentenced or have time remaining on their sentence. I think when all is said and done, the number of people who sort of fit in that category, meaning that a judge would actually have to resentence them, and that would materially affect a reduction in their sentencing. I think we may be talking dozens, not hundreds.
But how about for Trump specifically?
For Trump specifically, I would also be less worried about this for two reasons. One, the theory that well, it's not a theory anymore, it's the law, that this statute has to apply only when there's sort of evidence or documentary impairment. The January 6th indictment the Justice Department brings alleges that with respect to the electoral certificates and the so-called false electors, right? So even within the confines of the Supreme Court's decision, the Justice Department's prosecution would arguably meet the standard. Even if it did not, even if that statute, for some reason, the charges got dismissed or if the Justice Department dismissed them, which they will not do, all of the evidence that would be available or relevant to those charges would come in under the other charges anyway. The other charges that are pending under Section 241 and Section 371, those are the other charges pending against Trump. So practically speaking, all of the same evidence, all of the same conduct would come before the jury if this case goes to trial, and I'm dubious that it would, if there's a conviction, materially affect the outcome.
Yeah.
I know that there's more. I mean, I was struck. Mark said that this was quite possibly one of the most important decisions that was made this past week. And I was scanning the socials and reading through things yesterday, Mark, and it was the president and co-counsel of the NAACP Legal Defense Fund, President Nelson, and she said that it is notable that the court declined to hear McKesson versus Doe, which was the case that and left in place a ruling that basically said a a protester, in this case, someone who is aligned with the Black Lives Matter movement, can be, held accountable for the actions of other protesters, and police officers can essentially sue them. So they didn't want to take that up, but they decided to take this up. Why even decide to hear this case? What is the calculation here?
Simone, you're putting front and center, I think, something that is just not focused on enough. This U.S. Supreme Court heard just about 60 cases last year. Okay, out of tens of thousands of potential cases that they could have heard, they chose 60 of them. They chose a case to allow January 6 defendants to have charges, make it harder to prosecute them. They chose a case that involved Donald Trump's immunity, which by delaying the ruling in that, taking the case and delaying the ruling, they effectively conveyed immunity by delay and preventing him from having a trial before the election. They chose a number of other cases that allowed them to advance the Project 2025 initiative that you so eloquently dismantled the author of last week on the show. And what cases didn't they take? Right? They didn't take the cases that would protect the civil rights and the civil liberties and the voting rights of millions of Americans. And it is through that choice of what they take and what they don't take that the Supreme Court can do the bidding and the business that puts in peril so many things in this country that we worry about are being imperiled by another Donald Trump term.
What they take on Kush, what they don't take, and then what they move with great speed and what they slow walk.
Well, yes, and I noticed they all of a sudden got very patient and cautious with the abortion cases this year. Funny how that works. It's an election year, and they seem to have decided to kick the can on that, on those decisions, which I suspect if they were to come out the way the Republican appointees want, would cause another political firestorm in this country.
I wasn't even thinking of that. I was thinking just of the fact that we still don't have an immunity ruling.
Oh, well, there's that, too. That's absolutely correct. I mean, they've slow-walked that. As you know, we talked about this before. There should have been a summary affirmance of the D.C. Circuit's opinion. In this case, we shouldn't have taken this long at all. I share everyone's frustration and anger about where it's currently situated, and I'm prepared on Monday for an opinion that is going to be very disappointing and perhaps even enraging. But you're exactly right. I mean, and I just want to say I have one little sort of nit to pick with a lot of commentary about the Supreme Court, which is about, vote counting. Is it a 3-3-3 court or 6-3 court? That is just an artificial exercise, because the point that Mark made and that you identified is the exact right one. They pick what cases fall within the universe of the cases that they resolve. So you just have to, one by one, judge them on their merits, and I share the concerns.
And to that point, that would explain why the court tossed out the claim that the Biden administration coerced social media companies, where that injunction would have limited contacts between government officials and social media companies. Again, the big setup, folks, because now if the Trump administration comes on the back end, free reign between that interchange between social media and government.
Hey there, MSNBC fans. I'm Luke Russert, and be sure to join me, Rachel Maddow, Jen Psaki, Lawrence O'Donnell, Steve Kornacki, Joy Reid, and many more September 7th in Brooklyn, MSNBC Live Democracy 2024. Click on the link for ticket information. We will see you there.